languages.
Welcome to Caribbean Tea. From St. Vincent, Kendol Morgan, in Georgetown, Guyana, Denis Chabrol, and I am Vivian Williams in New York. Azruddin Mohamed, the presumptive leader of the opposition in Guyana, and his father, Nazar Mohamed, survived a fierce application by the government of Guyana to be remanded to prison while their extradition proceedings is pending. They were picked up by masked police officers in Georgetown in a dramatic fashion and taken before a magistrate after Washington transmitted an extradition request to Georgetown for the father and son duo to be brought to Florida to face an 11-count indictment. However, the odds were in their favor. Within hours, they were released on bail. The drama continues with sealed dockets, withdrawn charges, and an extradition fight that's testing the boundaries of sovereignty. It's a story of the Mohameds, the United States, Guyana, and the politics of jurisdiction. This is Caribbean Tea, the podcast where we stir the pot on the region's most pressing issues: social, cultural, economic, legal, and political, with unflinching honesty and thoughtful analysis.
For those who may not have followed the story from the start, the Mohammeds are among Guyana's most prominent businessmen, operating in gold trading, gold mining, currency trading, construction, and real estate. Their names have been circulating for months amid allegations of financial irregularities and tax evasion. Then came the bombshell, a U.S. federal indictment out of Miami charging them with wire fraud, mail fraud, and money laundering linked to alleged cross-border financial schemes. That indictment triggered a diplomatic chain reaction. It's formally requested extradition. Guyanese authorities executed the arrests, and in a dramatic fashion, the Mohammeds were brought before the court. But the government's push to have them remanded failed, and the pair walked out on bail the same day, setting the stage for a legal and political showdown that's now captivating both Washington and Georgetown.
And Dennis, what emerged here is more than just a courtroom battle. It's a confrontation between national sovereignty and international accountability, one that's forcing Guyana to balance domestic politics against treaty obligations to the United States. Washington's position is clear. This is a criminal matter rooted in U.S. jurisdiction. But for Guyana, every legal step has political consequences, from the withdrawal of local charges to the optics of cooperating with a foreign government against two of its most influential citizens.
Exactly, Kendall, and that's why today's discussion isn't just about a father and son facing extradition. It's about a country navigating the fault line between justice and politics, between sovereignty and the reach of foreign power. This case has all the flashpoints of a modern Caribbean legal drama: sealed dockets in a U.S. federal court that hide more than they reveal, withdrawn criminal charges in Georgetown that raised eyebrows about motive and timing, and an attorney general publicly defending a decision that may reshape how Guyana handles international prosecutions. So, what's really behind the secrecy of those sealed filings? Why did the Guyana Revenue Authority suddenly step back from its own case? And is the Attorney General's explanation a matter of law or a matter of political loyalty? That's what we're dissecting in this episode of Caribbean Tea. From Miami to Georgetown, from the sealed corridors of the U.S. District Court to the political hallways of Guyana, we're breaking down the legal strategy, the diplomatic choreography, and the power play behind the Mohammeds, the United States, and the politics of jurisdiction. This is Caribbean Tea. Let's begin.
When a federal court docket suddenly fills with sealed entries, that usually means something significant is happening behind the scenes. And that's exactly the case in United States versus Nazar and Azruddin Mohamed, a high-profile prosecution out of the Southern District of Florida, where the two defendants face charges of wire fraud, mail fraud, and money laundering. After the unsealing of the indictment against Nazar and Azruddin Mohamed, charging them with conspiracy to commit wire and mail fraud, money laundering, and related offenses, the docket went dark. What we started to see is a series of sealed docket entries. These sealed entries have generated some anxiety and speculation as to what is going on at the U.S. end.
By October 24th, entries numbered 4 and 5 appeared, both marked restricted and sealed until further notice. Then, in early November, a series of additional sealed entries followed, 6 through 10, all entered within a span of just 3 days.
To the untrained eye, that might look routine, but in the world of international white-collar prosecution, it speaks volumes. So, what could these sealed entries mean? Let's break down the possibilities. There was lots of anxiety in terms of what these sealed docket entries mean, but let's take a look at what are the possibilities, what could possibly be happening, and what may not be happening. Let's walk through the possible side of the chart. The first and most likely explanation involves extradition facilitation filings. Remember, the United States has already issued an extradition request to Guyana. To support that request, prosecutors often submit sealed motions asking the court for permission to share portions of the grand jury material. These materials, such as unredacted indictments or sworn affidavits, must then be certified for diplomatic transmission to Guyana. All of that is done under seal to protect the integrity of the process and prevent premature disclosure. Next, we have arrest-related papers. When an indictment is filed and defendants are outside U.S. jurisdiction, the court issues sealed arrest warrants. The government might later file sealed returns, updates from the U.S. Marshal Service, or Interpol notifications confirming that international coordination is on the way. Those would explain several of the early sealed entries that don't correspond to any public hearing. Then there's the possibility of sealed or protective orders. In cases that involve complex financial records or cooperating witnesses, prosecutors routinely request protective orders to restrict sensitive evidence, particularly where disclosure could compromise investigations in other jurisdictions. Some of the November filings could easily reflect those kinds of measures. Now, if we shift our eyes to the not likely side of the chart, we can rule a few things out. These are certainly not defense motions, since no attorney appearances have been entered for the defendants. They're also not arraignments or hearings, which would normally generate public minute entries, and they're unlikely to be routine scheduling orders or superseding indictments, both of which would appear by title on the public docket. We can also dismiss the idea that there are Section 1782 applications. That's a different kind of proceeding, usually filed as a separate miscellaneous case. So what we're left with when we put the clues together is a sequence of filings tied to the mechanics of extradition, sealed warrants, and the preservation of confidentiality around the evidence. The cluster of entries on October 24th likely reflects the initial set of sealed motions and orders authorizing disclosure. The follow-up filings in early November could mark the preparation and submission of the extradition package. When viewed through that lens, the sealed docket tells a story, not of silence, but of movement. It's a procedural choreography between Miami, Washington, and Georgetown, one that happens mostly in the shadows, until the day the defendants appear in a U.S. courtroom, if that day ever comes. So these sealed filings remind us that while American courts operate under a presumption of openness, international justice often unfolds behind closed doors. Every sealed motion, every restricted order represents an unseen chapter in the pursuit of accountability that crosses borders and tests diplomacy. So, Denis and Kendol, there was a lot of speculation as to what really was taking place when these sealed dockets entries keep popping up. So, in a quick review, here's what is likely taking place. In October, when we started to see those two entries, after step number 3, which we explained in the extradition process last week, the Department of Justice and the Foreign Affairs, or the Secretary of State for the United States, those have to be returned to the court. You have to have a warrant issued. All of that would have been sealed before the extradition request moved to Guyana. So the movement we saw in October was the preparation for the warrant request to move to Guyana. Now, we started to see some sealed entries coming back in November. Now, the extradition request was executed in Guyana. The Mohameds, 2 of them, were actually arrested. So you had to have a return of process to the district court in the United States, all of that under seal. Sometimes you have Interpol playing a role in this. So this is the U.S. reporting to the court in the United States, in the Florida, the developments in Guyana. Now, Denis, you would have recognized that during the proceedings in Guyana, there was lots of claims that the attorneys representing the government or U.S. interest were making claims without providing evidence. I think what you're seeing from the secret dockets is they're cleaning their act up for the next appearance. So what usually happens, in order for them to release additional evidence to Guyana, for instance, things like the grand jury minutes, they would have to make an application to the court for instance, grand jury minutes that was sealed, for redacted portions of that kind of evidence to be submitted to Georgetown. So those entries don't mean that there is any new indictment. There is no superseding indictment. It would have been labeled in that way. There is no new defendants added to the case that would be noted by the docket. What we could expect is that Georgetown now has more evidence in preparation for the next appearance of the Mohameds before the courts. All of that is sealed. All of that is kept wrapped up in this sort of a secretive process. So that's really what we're seeing taking place in the sealed dockets, or the mystery of the sealed dockets. No new charges, no evidence filed with the courts. Evidence are not usually filed with the court at this stage, so there is no additional anything here. The indictment is, as we discussed the last time, it's still the same indictment. Nothing has changed with respect to that at this point.
But while you say that these sealed documents may contain some material that might be redacted and ultimately be presented to the Guyanese magistrates court in the next hearing, at that juncture, those sealed in the U.S., they will be made public in the Guyanese courts. So how sealed is sealed?
Well, that's an important question that you asked, which is why prosecutors may go to the court and make an application. It might be by way of motion to say, here is this portion of the grand jury minutes we want to make available to our counterparts in Georgetown, unsealing portions of the evidence with strict instructions as to how things are to play out. So that's what you might be seeing there. And it is important for our viewers to know that this is sort of an informed analysis. We're not stating anything as a fact. We could rule things out based on an understanding of how the process unfolds and what different entries at different stages of the prosecution or the development of the case means. And when you look, for instance, moments before the sealed docket entries in October, you had the extradition request moving to Georgetown. So then you could use an informed analysis to say what you have there was the extradition request returning to Washington, and you have arrest warrants and all of that needed to move to Georgetown taking place. Then you saw shortly after the appearance in Georgetown, you see more sealed entries. What that will tell you is that once the Mohameds are arrested in Georgetown, as matter of development of the proceedings, there must be a report back to the court in Florida saying that there has been execution of the warrant of arrest and providing a report. All of that taking place under seal. So that's really where we are here.
But even though the extradition request was made to Guyana, when one checks the court records, one does not see any reflection of that stage in those documents. What's going on there?
So even though things are moving to Georgetown, it doesn't necessarily mean that entries are unsealed. They may be unsealed at a later time. So you may have reports to the court. For instance, we know that the Mohameds were arrested, so the warrants were actually executed in Georgetown. But the docket entry, the arrest warrant may not be unsealed at this point in time. So the court is informed, and a part of what you also have here is that the Mohameds have not had any defense counsel enter an appearance for them. So that probably could have changed the dynamics in terms of what might be sealed and what might be unsealed. And there's no motion from the defense here. So the Mohameds have not yet begun playing any of the possible strategies available to them, any of the options available to them in the United States. For this, for the moment, they are hatching or laying all their eggs in the Guyana basket. They are fully depending on proceedings in Georgetown, and we see no strategy and no movement taking place in the United States. Whether or not that's a good strategy is a different thing. The audience may have an opportunity to assess that as we continue our discussion here today.
Is the U.S. asking Guyana to arrest the Mohameds again?
So what happens? There is one arrest warrant. So the government always wants to have a defendant behind bars. In fact, the government usually wants to have a defendant behind bars. A government may build its evidence and may go back to a court and ask a court, in essence, to say to revoke bail. We don't know if evidence gathered by the U.S. and transported to Georgetown is part of boosting the case to say revoke bail. But surely what we are seeing is some level of coordination in order to ensure that what is taking place in Georgetown is boosted and is not deficient with the kind of criticism that you had in the first appearance of the Mohameds before the magistrate.
Just by way of reference, the U.S. court records show that there are at least 6 or 7 submissions that have been sealed, restricted until further notice. And I'm wondering, notwithstanding the fact that we just went through this in some manner, whether indeed any of these may be unsealed even before the Mohameds are possibly extradited to the United States.
Not usually. Not usually.
Why not?
What you may see happening is just sufficient for Georgetown to operate, just sufficient for the case to be made out in Georgetown. When, if the Mohameds retain counsel and begin to make motions in the United States, begin to deploy a strategy in the United States, you may see some difference, but not likely.
As we well know, during this past week or so, I think it was on November 6th, the Guyana Revenue Authority appeared in court and withdrew several tax-related charges against the Mohameds. And these are primarily due to undeclared income by the Mohammeds allegedly, but the GRA did not proceed with those charges. There are at least two other charges that are expected to come up during this week. They relate to one having to do with a alleged false declaration and alleged under invoicing as it relates to the Lamborghini luxury car that was imported by the Mohammeds. I'm not so sure whether those are also be withdrawn, but GRA did say that their decision to drop these charges as it relate to undeclared income was due to the extradition request, and of course the Guyana government deciding to proceed with that request, and also looking at various legal principles. They did talk about international poverty and so on as the bases for withdrawing those charges. Are these actually sound grounds for doing so?
Very interesting, uh, Dennis. Very interesting question. Is the government of Guyana acting properly? Is it abdicating its responsibility as a sovereign to address what we discover are criminal proceedings pertaining to sovereign wealth, sovereign resources, matters such as the collection of tax revenue? Remember, we're not dealing with a case where the usual fugitive, someone commits a usual crime in another country and has fled to another country, and you're trying to help out another sovereign. Neither are you dealing with a case where someone is sitting in your territory and using means within your territory, combined with co-conspirators within the territory of another sovereign and committing crimes, and therefore you're cooperating with that sovereign to have those crimes prosecuted and bringing the either the accused or the convict to justice. That's not what is happening here. What we have here are criminal matters pertaining to crimes in Guyana, and those crimes pertain to matters of deepest and sovereignty and national interest. So we'll discuss whether it is the grounds are sound for the government to step back, when it is a sound executive decision. I think that's the question you are getting at. But what we have discussed last week, and we pointed this out in a previous episode, which those who haven't seen the previous episode should go back and look at the collection of episodes that we have done on this particular matter. So we pointed out that the extradition treaty forbids extradition proceedings progressing if the defendants are facing any other charge in the country, or have any penalty that they haven't yet fulfilled pertaining to any offense or charges in the country. Sovereigns are not supposed to give up sovereign matters and matters of sovereign interest to um, allow another sovereign to pursue criminal matters. And when we talk about comity, that is what we are talking about. So when we talk about comity and we talk about mutual assistance, really when you have a matter of significant interest to the sovereign, Guyana, the question is whether Guyana should not be in the same vein asking the United States to say, here, we have a serious problem with respect to our sovereign resources. Help us prosecute this matter. So the United States is helping Guyana in Guyana, not Guyana sending or sort of outsourcing the prosecution and justice to the United States. And this is the justification that has been given by the Revenue Authority, that the explanation is that they had to remove impediments to extradition, and the impediment would be that you have pending offenses that the Mohammeds are being prosecuted for. The treaty goes further to say if there are pending investigations. So even if the investigations have not crystallized into criminal charges, as long as their investigation as a sovereign under the treaty, you have a duty to complete that before you send someone who is the subject of extradition overseas. So we have multiple issues with the Mohammeds. We have the Lamborghini, which is part of the actual offense for which they are indicted in Florida. And then you have other issues pertaining to tax and revenue evasion. These are matters that also are before the court according to the indictment in the United States. So what we see is the government more or less trying to pull these things back to clear away the obstacle to the extradition proceedings. This is a good point for me to bring in the Attorney General and hear what he says and his justification for what is happening.
It is an accepted principle, a very self-evident and established principle of extradition law, that you have to adjust domestic arrangements to accommodate extradition. All countries are required to do it. Mm-hmm. And
is it part of this?
Yes, it's part of this. It's part of our treaty. I saw someone posted Article 4 of the treaty that expressly says that you have to adjust your domestic affairs.
Well, let's fact check the Attorney General here. Let's do a fact check on the Attorney General. He's talking about Article 4 in the treaty. Is he accurate? Well, it's could easily be addressed if we read what the treaty says. Article 4 says that the extradition shall not take place. The extradition shall not take place if the person claimed has already been tried and discharged or punished, or is still under trial in the territories of the high contracting party applied to, for the crime or offense for which extradition is demanded. And secondly, if the person claimed should be under examination or under punishment in the territories of the high contracting party applied to for any other crime or offense, his extradition shall be deferred until the conclusion of the trial and the full execution of any punishment awarded to him. The Attorney General is absolutely wrong, and I am going exactly off of Article 4, which he refers. Article 4 places a duty on the sovereign to ensure that matters at home are taken care of before you actually send anyone or defer to another sovereign as part of any comity. It does not say that you will adjust your proceedings. You don't withdraw pending proceedings before the court in order to outsource justice to another sovereign. And so when you look at the very treaty provision that he is referring to, that the sovereign, Guyana as a sovereign, the state, the Guyana Revenue Authority, the Attorney General, and the Ministry of Foreign Affairs and Home Affairs have a sovereign duty to adjudicate the matter fully, to complete its investigation, prosecute the matter fully, and not only that, after it's prosecuted the matter and awarded penalty or imposed penalty on the subjects of the extradition, to make sure that that is fully complied with and satisfied before deferring to the any other sovereign on extradition. The government here has done the opposite. What it is doing, it is simply withdrawing and retreating and abdicating its sovereign duty to outsource its sovereign responsibility to the United States. This is in violation in the letter and spirit of the treaty. If you wish to say the letter, I will argue that it is the letter and the spirit, because the government has started an investigation. It is trying to put that investigation on hold. It has started prosecution. It is trying to put that prosecution on hold, on the back burner, in order to facilitate the United States. And that's not what the treaty says. And this goes to the very concept of comity, the concept of recognizing the importance of sovereignty and a sovereign. Sovereigns also have a duty to protect their subjects, even from other sovereigns. So there is also some other interesting dynamics at play here, Dennis. Now, if
But,
you
but,
have
but
a
Vivian,
charge against the Mohammeds, and the claim in Florida is that the government of Guyana has defrauded. Now, the criminal proceedings have been withdrawn. If you withdraw those criminal proceedings, are they withdrawn with prejudice? If they're withdrawn with prejudice, if they're dismissed with prejudice, it means that the government of Guyana is barred from raising that or prosecuting that issue. That's the end of it, right? And that could be viewed as conclusive evidence that the underlying fraud that the United States needs in order to establish that there has been wire fraud has been adjudicated in a court and dismissed in a court in Guyana. But I would just simply put out the scenario, Dennis. Do you think if Guyana makes an extradition request to the United States to prosecute someone who committed a crime in both United States and Guyana, that the United States, as a matter of comity, is going to let that subject be extradited to Guyana to be tried in the in Guyana and not in the United States? You think that the United States would make accommodation, as the Attorney General will say, because it received an extradition request? This is a complete false explanation that is offered with respect to the withdrawal of the pending criminal matter by the Guyana Revenue Authority. Even in the
yeah,
United States, you have very often tussle between uh, districts as to which district has jurisdiction, and sometimes you have state and federal jurisdiction, and they don't yield like that. They don't just simply say, as a state, we just hand over to the federal government. You have complete tussle as to who gets a first bite, who gets a first crack at it. So what is developing is a precedent that is very troubling and concerning. But we could move on with discussion here if you have any questions or anything you want to raise here, Dennis and Kendall.
what if there's a situation where the United States has much more concrete evidence that can lead to a conviction of a crime that has transboundary implications?
That's a good question. I think that there is. I made a note to address it, and I would. That is part of uh, the criticism of Guyana abdicating, of Guyana ceding jurisdiction to the United States. The case before Guyana is way stronger than the case before the court in the United States. The case in the United States hangs by a thin thread. If
Well, what
what is
evidence do
taking
you have to
place,
support that?
the question you ask is a very important issue as to what could the United States do and whether it could prosecute matter of this nature. What is the boundary of the jurisdiction of the United States? The Attorney General of Guyana has a position on this in terms of the national or international nature of the indictment against the Mohameds. So let's listen to the Attorney General, and then we'll come back and talk about that.
I hear people say, but The Americans didn't lose any money.
Yeah.
It is not about that.
Yeah.
Money, look, you have cases where persons in Barbados are conspiring to send cocaine to the United States. The conspiracy was just completed. Not a gram of cocaine has left Barbados or entered America in relation to that. Yet the people were extradited.
Now, let's break this down clearly because there is a lot of misunderstanding about what the United States can and cannot prosecute when the alleged wrongdoing involves foreign resources, foreign revenue, or foreign laws. The US does not have a blank check to charge people for conduct that involves another country's laws. There are three major legal limits that shape what Washington can do. One is the presumption against extraterritoriality. Two is the revenue rule. And three, statutory limits, including reciprocity requirements for smuggling related offenses. Let me walk you through each of these. Now, the presumption against extraterritoriality. US law generally stops at the US border unless Congress clearly says otherwise. That principle was at the heart of the Supreme Court's decision in the Pasquantino versus United States case that we discussed at length in our last episode on this subject. In that case, the defendants used US wire communications to smuggle alcohol into Canada to evade Canadian taxes, and it also used co-conspirators within the United States. All of this was taking place within the United States using means that were in the United States. Now, the court did uphold the prosecution under the wire fraud statute. That was on the wire fraud. But it did not say the US can prosecute foreign tax crimes. Instead, the court said, if you use the US wires to commit a scheme, even one targeting a foreign government's revenue, and you're operating within the United States with co-conspirators within the United States, the US can charge you with wire fraud because the focus was on misusing the US system, not enforcing foreign laws. And of course, we discussed the split in the Supreme Court in Pasquantino in the last episode. Now, that's not what this case presents. The key point, right, is the dissent. The key point the dissent in the Pasquantino case made, and it is important here, is that Congress usually writes laws for domestic use, not for policing the world. And unless Congress explicitly extends a law overseas, courts should assume it stops at the US border. That's the presumption against extraterritoriality. Now we move to the revenue law. And the revenue law is based on a principle called the revenue rule, which we talked about last week, but it's particularly relevant here. This is a centuries-old doctrine that prevents the US courts from enforcing foreign tax laws. That means the US cannot prosecute someone for evading Guyana's taxes or for violating Guyana's export duties or for breaking Guyana custom laws. But, and here is the nuance, the Supreme Court in the Pasquantino case said the revenue rule does not block a prosecution under a US statute if the foreign government tax loss is part of the story of sitting in the United States and using wire and co-conspirators to break the law of a sovereign in another state. So what US courts cannot do is determine whether Guyana's tax laws were actually violated, cannot enforce Guyana's tax law assessment, or collect Guyana's tax loss revenue. The revenue rule prevents it. The US cannot and is not prosecuting the Mohameds for gold smuggling, export evasion, or tax fraud against Guyana because it cannot. What it is doing, it is seeking to structure the allegations and the indictment against the Mohameds to fit wire fraud and money laundering. So the other issues that I raise, those are matters for a foreign jurisdiction. And the last one is the statutory limits. The U.S. has an anti-smuggling legislation, and it requires it has what is called a reciprocity rule that says that the United States cannot prosecute for smuggling the resources of another sovereign. And these matters are largely tied to the whole principle of comity and sovereignty. So the way US deals with the question of smuggling is if you're smuggling something in the United States and you're evading US customs, that's not the allegation against the Mohameds. If you are smuggling contraband into the United States, the US has jurisdiction because you're creating mischief and crime in the United States. If you are, for instance, evading customs or you're doing something in the importation, and even where there is the reciprocity rule that occurs, the US will only be able to engage in smuggling if someone is in the United States and is smuggling across to another country, as in the Pasquantino case. The Attorney General is making the error of using drug smuggling and equating it with smuggling of gold. The United States cannot prosecute anyone for the smuggling of Guyana gold. It has to find a different crime, which is why when they seized the gold in the first instance, they brought no charge because they could not have charged the Mohammeds for smuggling. They resorted to sanctions. It is the reason when you read the indictment, smuggling is just part of the story. It is not a charge in the indictment. I'll come back to your question, and it's a very insightful question. When Guyana refuses to prosecute anyone, the Mohammeds or anyone, for smuggling its natural resources or evading its taxes, it is forfeiting prosecution of its sovereign wealth and matters pertaining to its sovereignty for which the United States cannot prosecute. And why it is, I say that the case again. Go ahead, I'm hearing you. I'll pause.
Yes, but Vivian, I'm looking here at references being made to the Money Laundering Control Act in the United States, 1956 and 1957. And you're saying that non-U.S. persons can be prosecuted, at least in part in the U.S., even as minimal as the transferring of funds through a U.S. correspondent bank account involving a U.S. bank. And here we are talking here, for instance, about things related to not only the gold, but in terms of the use of the banking system for the movement of funds for the transactions involving the Lamborghini. So how is it you're saying that the U.S. doesn't have extraterritoriality as it relates to tax matters?
Well, so here's where you are misstating what I said. I am saying that the United States is structuring the criminal prosecution not with respect to Guyana's sovereign resources. It is trying to construct a wire fraud and money laundering, which is not prosecuting the Mohammeds for smuggling Guyana's sovereign wealth. So if Guyana's
but gold is only one. The gold-related matter is only one. There are other matters concerning the use of the... But
Dennis, let me finish. You're missing what I'm pointing out here. If my natural resources is significant to me, it would be improper as a sovereign for me to forfeit the prosecution of the theft of my natural resources. If my sovereign resources, and there's another, in his interview, the Attorney General talk about revenue is like the second most important thing to a sovereign nation. And this is why the revenue rule and all of this has become part of comity, right? So when the Guyana Revenue Authority says we are taking a back seat, it is taking a back seat and it's forfeiting the most important aspect for which sovereigns exist. And it is not like it is even saying US prosecute gold smuggling for us. The only thing the US could prosecute is wire fraud and money laundering. Those are different crimes. And I would point out to you, and I'm not trying this case, that because the United States cannot make a determination as to the fraud, as to the how much of the as to the smuggling of the gold and the natural resources of a country, and as to the revenue owed by a citizen to another sovereign, that means that the wire fraud and money laundering case must rely on a predicate crime, and that predicate crime is the smuggling of Guyana gold and the evasion of Guyana's taxes. And it is those predicate crimes that Guyana is withdrawing. So you're trying to prosecute, you're handing over prosecution to the United States to prosecute money laundering and wire fraud that depend on the predicate gold smuggling in Guyana and the predicate tax evasion. The United States cannot even make a determination as to that. And that's the significance of Guyana stepping back in this particular case, to simply allow the United States to take over the prosecution of the matter. And I make no claim as to whether the United States could make out a case on wire fraud or whether it could make out a case on money laundering. But both of those two charges require first the predicate offense of smuggling, which the United States cannot determine, the predicate offense of tax evasion, which the United States cannot sit as a sovereign and make a determination. This is a perfect case for which Guyana as a sovereign should say to the United States, someone is bleeding my natural resources. Someone is evading my sovereign wealth, my tax revenue. Help me with your superior financial resources using comity and mutual assistance agreement to solve this. So that's the point I am trying to make here. Any questions?
Essentially, you're of the view that if Guyana, which you figure has a stronger case, goes through and gets a conviction, it strengthens the efforts of the U.S. to bring its own matter against the Mohameds, and that them not prosecuting it is in a sense giving up on them dealing with what is a fundamental matter in relation to the country's natural resources. So it raises the question, I think, of what sort of influences that may be impacting on the decision of the Guyana government.
Well, so at some stage before we wrap up, I guess we'd look at the aspect of whether there is any political implications and political motives here. But what you raise is a very important aspect. Proceeding in Guyana before the United States is a better course of action because the United States as a sovereign cannot determine some of the matters, some of the factual matters, the predicate crimes needed to prove its case in the United States. So you would think that the United States would help Guyana to prove the tax fraud and the gold smuggling, and then take the evidence from Guyana and then just use that evidence to further the wire fraud and the money laundering. And you have you have to ask whether the government of Guyana believes that a jury in the United States is going to sit back and say, oh, we're going to take some statement from the Guyana Revenue Authority that says the Mohameds are indebted to or defrauded the government of Guyana $191 billion. But we withdrew the criminal charges against them for this. Isn't a jury entitled to view the withdrawal of the case, whether or not it is with prejudice, as a significant factual matter from which it should conclude that there was no fraud?
There's a question that is on my mind.
Because what you're asking the jury to do is to find and convict, forfeit property, and send people to 20 years in jail for each of the counts. Which jury you think is going to do that? Go ahead, Kendol.
Yeah, the question relates to, while it is that the U.S., as you're saying, can only focus on wire fraud and not say on things like tax evasion, wouldn't the conduct of the case in the U.S. require presenting evidence of these? And so while the overall objective of the case may be in meeting U.S. legal requirements, just focus on wire fraud, couldn't it open up the matter of by virtue of the evidence that they may be able to pull in, cover the evidence that would have come out of a case of the case being held in the Guyana jurisdiction, being brought in as evidence?
How do they get to that evidence? Because the United States cannot sit in trial and make the determination. Even if it has the evidence, as a sovereign, it is forbidden from making an assessment of tax fraud. It is forbidden from doing that. It is forbidden from establishing smuggling. So it can't sit in its court and make a factual finding that there is smuggling. It can't sit in its court and make a factual finding that there was tax evasion and the amount of the tax evasion. It has to rely on Guyana to make that factual finding. And Guyana is withdrawing in that investigation and that criminal prosecution. So what is going to happen in the United States? Are we going to say that one person in Guyana, probably the head of the Revenue Authority, is going to write a letter and say, I have determined that these people that I have not provided due process, and when I was confronted in court with this evidence, I withdrew the case, but I'm sending you a letter in the United States that I have made a determination that these people defrauded us by $191 billion in Guyana? Which jury is going to take that? And which is why I'm pointing out that what the Revenue Authority has done is not only abdicate from its responsibility in protecting sovereign resources, it is weakening the case, even that the United States is prosecuting, simply to extradite someone. So it seems the end is not to help Guyana and to plug a hole with respect to the smuggling of its resources and any fraud with respect to its revenue. It seems like the end goal is just extradite these people. And once we get an extradition, that the outcome has been satisfied. So you have to ask, what is the outcome? And that's where we go to the question that either you or Denis raised. Is there some sort of political motivation behind what is going on, right? I want to move to another clip from the Attorney General, if there isn't another immediate question that I want to address. And then we'll come back and continue to discuss this.
How do I balance the competing interests? First of all, the interests are not really competing. On the one hand, the state of Guyana has international obligations. on the treaties that it would have signed and on the international law and international practices. Among those international obligations is extradition. And there are existing relations between and among nations to use this process in order to transport to different countries persons who are accused or charged with the commission of offenses across frontiers. Guyana has a duty as part of its global obligation to participate in the fight against transnational crimes, organized crimes, and criminality generally, to assist in this process. And Guyana has a track record of so doing. It is a process that is based upon international comity, reciprocity, and mutuality. And countries are expected to cooperate with each other in this international arrangement.
What's your takeaway? Here's the Attorney General talking about comity, these international community that Ghana is a part of, multilateral cooperation. Do you have any takeaway from this before I comment?
My view is that it's that there are two sets of matters that Mohameds seem to be facing. One in the United States jurisdiction, one in Guyana, and there seems to be, in the view of the Guyana administration, some reason for wanting to lean towards the U.S. jurisdiction. Of course, there are legal expectations because of the treaty obligations that the two countries have. But a trial in the United States may be seen as one that would have greater impact on what's expected to play out in the Guyana political and other situations. So there may be reason for wanting to lean in that direction, and so you create a reason or an explanation for wanting to go in that direction, and making it as if, well, I mean, we have that obligation that we need to fulfill.
Well, Kendol, that's an important point. Are you talking about the impact of a U.S. prosecution on WIN?
Indeed, and the leadership of WIN.
So that could be a calculation. In a later segment, we will address the politics of this jurisdictional issue, and we will get to that. But when you look at the logics of what we are talking about, it raises question as if that is the outcome that is being pursued, rather than really fixing serious matters about natural resource bleeding that is taking place in Guyana, and whether there's any serious approach of fixing issues pertaining to tax evasion that affect and hurt Guyana. So it raises those questions. Denis, I don't know if you want to come in here or whether I should continue, if you have any observation you want to make here.
No, you proceed, please.
All right. So here is one of the things that is concerning about the approach the Attorney General makes. Well, comity is a hand-wash hand kind of situation, isn't it? The same treaty that Guyana has with the United States has with Guyana, doesn't it? And
Yeah.
the way the Attorney General describes Guyana's obligation is as if Guyana was a side chick, some sort of impotent that has no say and doesn't cannot request any sort of reciprocal help from the United States. This seems to me to be a perfect case by which Guyana would say to the United States, look, you seem to have the evidence of something that is hurting us as a sovereign. Help us solve it. Guyana could request, for instance, expert help from the United States in trying a case even in Guyana. Any of the evidence that Guyana wants that the United States has, can't Guyana receive that help through the same mutual obligation? Doesn't Guyana believe that the United States, as an international partner, also has an obligation like Guyana think it has to the United States to provide that? Can the Guyana not, for instance, say, send a few prosecutors who are skilled in this kind of prosecution as consultant so that the AG's department may even gain what is called human resource and other help in prosecuting that case? So it is not a case that Guyana can't get help from the United States to do it. It's a case where Guyana is simply abdicating as if it is just a passenger in the whole process of comity, and that it as if it has it doesn't, it's not a participant with a voice. It's not behaving like someone who has an important seat at the international table. And that is concerning for a country that is now an oil producer, a major flashpoint in global development. We're still behaving like the dependent, like the dependent state, exceedingly dependent state, helplessly dependent state that has no seat and no voice at the table. And I think that disposition is troubling from the Attorney General. I want to make a further statement with respect to that. I would say before we go any further, let's clear up a major misconception. The United States is not prosecuting the Mohameds for gold smuggling. And under the facts, we know the United States cannot prosecute them for gold smuggling. Not in this case, not under US law, not based on the allegations that are coming out of Georgetown and Florida in the indictment. And here is why. I'll repeat it. The gold exported by the Mohameds was shipped to the United States through lawful channels. It wasn't a backtrack. It's not counterfeit. It is proper gold. There is no allegation in the indictment that the gold was not declared to U.S. authorities or that it did not comply with U.S. customs requirement. And there is no allegation, none, that the Mohameds evaded American duties or defrauded the United States. Under the law, to prosecute smuggling, the defendants must have, one, falsified U.S. custom documents, avoided U.S. taxes or duties, imported contraband, or violated U.S. import restrictions. That did not happen here. It's not pleaded in the indictment. So the U.S. cannot call this gold smuggling. It doesn't have the authority to so determine because there was no smuggling in the United States. Whatever may have happened in Guyana, the goods entered America lawfully. So if the United States cannot prosecute smuggling, what is the U.S. case about? It is based, as I said, almost entirely on a thin thread of wire fraud and money laundering, charges that rely on the use of U.S. financial systems, not on the gold itself. And that distinction matters. It matters for Guyana, it matters for sovereignty, and it matters for the entire Caribbean. Because here is the bigger truth and issue the Attorney General is not acknowledging or has overlooked. The United States is not prosecuting this case because of gold. The United States is prosecuting this case because of the wires, banks, emails, transfers, electronic records that pass through American networks. This is the narrow jurisdictional hook, a hook created by the US Supreme Court in that Pasquantino case, which we talked about in the last episode, which allows the US to prosecute a fraud against a foreign government if communication systems within the United States were used. But let's be honest, that is a very thin basis on which Guyana is effectively surrendering jurisdiction over one of its most prominent families and one of its large tax-related cases and its sovereign resources. Guyana is not required to do so. Comity does not expect it to do so. In fact, the treaty with the United States expects it not to do so. Under international law, Guyana could have prosecuted the substantive offenses, the alleged false declarations, the bribery of its own officials, the evasion of its own revenue rights, right in Georgetown, Guyana. Instead, Guyana has ceded or is ceding jurisdiction to Washington on the back of what is essentially a technicality, that a few data transfers and banking records happen to touch American servers. And that decision carries enormous consequences, because if the US could prosecute Guyana's gold exporters today simply because money passed through American wires, then tomorrow the US can prosecute Jamaican business owners whose shipments use US banks, Trinidadian energy companies that settle contracts in US dollars, Bahamian executives whose emails route through US servers, Barbadian traders who clear payments through New York, and Guyanese politicians whose communications happen over US platforms. In today's world, it is nearly impossible to conduct business without touching an American financial institution or server at the same point, which means under this expanded jurisdiction, the United States can reach into almost any Caribbean country at any time and claim authority. That is the real implication of Guyana stepping aside. And it has implications on two fronts. The political fronts, America could simply look at these tenuous connections through transactions and communications to go after Caribbean politicians it dislike and create indictments against them. It could use this same tenuous connection to go after companies in the Caribbean that it dislikes or disfavors. And companies usually look out for its business sector. Part of its sovereignty is to protect its business class. So what this case is simply saying, and the precedent that is created in the manner in which authority is being ceded by Guyana, is that you could become one of the most successful conglomerate in the Caribbean, and the United States, with a click of a finger and the scratch of a pen, making tenuous claims such as transactions in the United States, a purchase in the United States, an import from the United States, and an email communication from the United States could end that company. If, for instance, there is a significant Guyana industry or company that is vying and has developed capacity in the oil industry, and it becomes a serious competitor to Exxon or one of its suppliers, and the United States disfavors it, it could cripple it, not through commerce, not through competition, by simply extending extraterritorial jurisdiction in this matter. It is for this reason that the role of the Attorney General is extraordinarily significant. It is not as simplistic as he puts it. This is not a case about a person sitting in Barbados, in Bridgetown, Kingston, or Georgetown conspiring to ship drugs. This is a different type of indictment, and these issues are different.
Very strongly put, but I guess people may raise the counterpoint that At least the Attorney General cannot just pick up whoever is accused and ship them off to the United States. We do have a court system that will have to make a determination on whether, in fact, what the U.S. is requesting can be granted. So isn't that a sort of an insurance to the companies, the individuals, the politicians who the U.S. may have in its sight?
Well, that's why this case is an important case that we are tracking. And that's why this is a case that requires judicial watch. How the judiciary responds, how the litigants in this case frame the issues and litigate the issues, how the business class in Guyana recognize the connections in the issue, frame the issue, and how pressure is brought on the political executive class, the ruling party, will determine significantly the future of commerce and U.S. Political reach and influence in the Caribbean in the future. So we have to watch this case to see how the issues are unfolding and how the courts rule on the issues here. And you raise a question, Kendol, with respect to political implication. It's a gamble. It's a gamble by the government that if they simply extradite the Mohameds, that their star falls and simply evaporates. And that could be a bad gamble, because what it could result in is that the Mohameds may prevail and appear to be those that have the fortitude to stand up against foreign influence and not become what some may say puppets of the United States. The present regime also already has the issue of the manner in which it has failed to tackle and to redress issues pertaining to another natural resource, which is oil, not renegotiating the oil contract, not sounding firm, not sounding like a firm defender of the sovereignty and the sovereign wealth of the country. And if they take this chance and don't consider these complex issues and the Mohameds win, Azruddin could well become a political hero, not only in Guyana, but across the Caribbean. If he comes to the United States and his lawyers raise these issues that the Attorney General overlooks, and the courts in the United States, which I have pointed out, are highly likely to rule in his favor, he could lose, but it is highly likely that he could also win, and he prevails. And if the courts in the United States have to tame the executive in the United States and say, you are stretching our laws way beyond the boundaries that Congress intended these laws to stretch, Azruddin Mohamed will become a significant political figure, not only in Guyana, but in the Caribbean. We must take into consideration that right now the U.S. Supreme Court is hearing matters as to whether President Trump and the tariffs that he has set internationally is stretching his authority beyond the boundaries that he has. So it is not that the executive in the United States doesn't flex its muscles and go beyond. And we heard a skeptical U.S. Supreme Court saying, wait a minute, what gives you the authority to stray so far from home? What gives you the authority to raise revenue? What gives you the authority to be sort of operating in this way, in this same international community that the Attorney General talks about and acknowledge the idea of a community of nations? So I want to put that out there. If there's no further question, I want to move quickly to another clip from the Attorney General for us to talk about.
We made requests for extradition for Marcus Bisram. We went through the same process. Magistrate, DPP, clerk of court, they put the stamp on. The Home Affairs Minister put her stamp on. The Foreign Affairs Minister put their stamp on. And when it went to America, The Americans acted upon it. They did what they had to do in America, and they sent Marcus Bisram home to stand trial for whatever the request was for.
Here is the Attorney General using the Marcus Bisram case as an example. The Mohameds case is not the same case. Marcus Bisram was a fugitive from Guyana wanted for murder in Guyana. And he was present in the United States. The United States did what sovereign states do, help each other, and they sent him back. And here is one of the things that the Attorney General doesn't consider. Do you think a court in the United States would have sent Marcus Bisram back if Marcus Bisram had committed an offense in the United States? Do you think that if Marcus Bisram had any simple criminal offense or an outstanding warrant in the United States, that the United States would have packed him up and shipped him to Guyana? So the comparison is not apples to apples. And again, it gives the impression that the Attorney General is failing to comprehend the gravity of what is before the government of Guyana and the weight of the executive decision and the judicial decision that Guyana has to make in the Mohamed's case. Your comments, if you have.
Well, clearly a matter of a superpower and a smaller power, and I think everyone would agree that there is this very regular practice by the U.S. to overreach, and that developing countries tend to just toe the line, and it seems to be what is playing out here in part. But it's also, I think there may be the view that it's also playing in the hands of the authorities in Guyana, and so this is a way of trying to justify the action. It is probably what the authorities want to play out, unless there is a desire by the administration to seek restitution in short order from the Mohameds. It would seem that they're thinking maybe that if there's a conviction in the U.S. courts and there is a lengthy sentence, that may cover the punishment for whatever transgressions may have been conducted in the in Guyana's jurisdiction, and that perhaps even later on the matter of restitution can be further applied. But that for the time being, maybe the ceding of this apparent control to the U.S. court may work in the favor of Guyana's authorities, and that there would be punishment if there's a conviction, and then, as we mentioned earlier, there would be the political implications that may be seen from this.
Well, Kendol, so I want to take you up on that. A couple of points I want to make. First thing, America can't make a conviction for smuggling. It's wire fraud. Any forfeiture, any sort of fines is going to the American coffers because it is for violation of American laws, and those will be in keeping with what America is entitled to. Guyana gets no recovery from that. It would be an abdication and completely improper for Guyana to say we're going to sit back and then we're going to park these matters and then we're going to try these things later. I want to put it this way. If you are a significant, if you have a significant enterprise and someone says to you, one of your employees is stealing your resources, stealing big from you, what would you be interested in? Would you be interested in just catching that employee, prosecuting that employee, Or would you be more interested in, say, how is my security and my measures that I have in place, the safeguards, how are these measures violated? What is happening home that is causing this? How could I plug that gap? In essence, what is more important to Guyana? The Mohameds being extradited, the Mohameds serving time in the United States? What does the United States, as first-time offenders, give them a nice sweet deal and say 3 years in jail or whatever the case may be, or 5 years or something? I'm just calling some numbers. Isn't Guyana more interested in whether even some of the major gold mines owned by foreigners, other local people, are also violating its system, and that it has bad eggs in its midst that is permitting an extraordinary level of depletion of its sovereign wealth? Isn't it more interesting, or shouldn't Guyana be more interested in whether its timber, its gold, its diamond, and a whole host of other resources are being fleeced in this manner? And that could only happen if Guyana thoroughly investigate what claims that the United States makes against the Mohameds in the context of the leakage in Guyana, the problems in Guyana that give rise to that.
There could be
If
the
the
question
Mohammeds
too.
are doing it, there has to be suspicion that even foreign players are doing this. And my point here is this seems to be a case where the government of Guyana should have opened up rather than close investigations. There seems to be a case where there should at least be a commission of inquiry. How all of the oversight agencies failed, and who are the parties that might be complicit? How did this happen, and how could we prevent it from happening? The government of Guyana, as the protectors, as acting as a sovereign, must take steps to protect the wealth of the nation, must take these steps, and it is not taking these steps when it simply park these very important issues and and offer a blind eye just simply to say we're happy with one person being prosecuted. We don't even know if the person being prosecuted or persons, if they are guilty, are the biggest culprits that are fleecing the system. So it is my view that all of the examples given and all of the reasons for the abdication or by Guyana are not proper reasons. Kendol, I think you and Denis have raised the issue of what really might be, and if there is any motive other than a straight legal process that is taking place, what possibly might be the political implication and fallout from all of this. This is something that has been percolating in Georgetown and elsewhere. I think there's been sufficient noise about it that caused the Attorney General to address it in his interview. So let's hear from the Attorney General and let's see how he responds to questions raised about whether there is a political motive at play.
The two subjects of the extradition requests were not politicians when these things happen. The offense that is charged are not political in nature in any form or fashion. How the political argument came about? You know how it came about? It is after the sanctions came from the United States government, and after it was clear that extradition requests were to follow, one of the subjects entered politics. It is he who made it political. And now he puts up politics as a shield. he made a conscious decision to get into politics knowing that this was coming. And then say that, you know, so if there is any politicization, it is from the subject or subjects themselves. They introduced politics. It's they who entered into the politics after. Is that it? It was, and when you read up on what political driven extradition is that the requesting state, because that is where you're going to be prosecuted. You're not facing trial here. So it is there that the politics ought to be emanating. I don't know that they are involved in American politics.
Well, that's the Attorney General's take on political interference. And I think we all know that the U.S. has different ways in which it makes political leverage. And we all know that political interference, domestic and foreign, comes with many different flavors. And I don't know that political interference is an area that is so straightforward and simplistic as the Attorney General puts it. But before we dive into that, Guyana has a rich history of political interference and political interference with the United States at the center of it. I don't know if the Attorney General recalled that his own party was part of and parcel and at the center of that political interference and involvement of the United States in shaping the political landscape and the nature of political power and influence in Guyana. Denis, you are a person very aware of this kind of history, being a journalist that has been in the trenches in Guyana for decades. Help our viewers understand Guyana's political history and U.S. influence.
Well, the United States has had a historical influence in the politics of Latin America and the Caribbean. And of course, that includes Guyana during its pre-independence period, where it had feared that the then founder leader of the People's Progressive Party, Dr. Chedi Jagan, would have established a so-called second Cuba in the hemisphere. Hence, it worked along with the British colonial power of Guyana at the then time to ensure that the electoral system was of such that it could eventually lead to Dr. Jagan being removed from power in 1964, although he had a coalition, although he had a plurality of the votes. The electoral system allowed that's a proportional representation electoral system as opposed to the first past the post, which he had always won under. So when the 64 elections were conducted under PR, he won a plurality, but there was a coalition between the People's National Congress and the United Force that saw the removal of Dr. Jagan and the PPP from power. That meant that that in 64, the PPP was declared the loser of that election. Fast forwarding now to court and politics and so on, I mean, the reality is that any politician who is at the center of any controversy or has a political stake in the country, one way or the other, and is charged, automatically politicizes that charge, or any efforts to prosecute them as being political. We saw that being done by political parties across the spectrum in Guyana, more recently in the case of Dr. Finale, prior to when the coalition was in power and there were 18 fraud charges in relation to sale of government lands. He was charged, and of course the PPP at the then time politicized that and said it was part of a political vendetta. Likewise, investigations went on at the level of Soku. A number of PPP persons were actually taken to the Special Organized Crime Unit. A number of them were charged as a result of audits. And of course, the PP at the then time said all of these were politically motivated. Now we're seeing the case of Azruddin Mohamed. Never mind the extraterritoriality of some of these matters, or in fact, some of the indictments. Here it is. He, as a political player now, is saying that the PPP was part of this plot to have him removed from Guyana. I have no evidence at my fingertips to suggest that there is a conspiracy between the government of Guyana and the authorities in the United States to have this done. So, but all I'd say to you and to the viewing public is that this is the way politicians operate. They always seek to play the victim, especially when it comes to matters dealing with the court and prosecutions and investigations.
Kendall, do you want to come in here with some parting words?
Yes, and it could take the form of a question. How do you react to the point being made by the Attorney General that this matter didn't start as a political matter, that in fact the two indicted persons were in fact business persons, and one decided to throw Sati in the political ring, and that could be interpreted as seeking political cover for the legal troubles that he was seeing ahead of him. I think it may give the appearance of being somewhat different to some of the examples raised a short while ago by Denis. How would you react to the public seeing it that way?
Kendall,
Well,
first thing I could say that we could do a fact check on that. It is not factual. It is not precisely factual that the Mohammeds enter politics after the U.S. sanction came. In fact, Azruddin Mohamed's father, who is indicted along with him, entered politics long before, and he entered politics on the PPP side. He was a candidate for the PPP in the last local government elections. So that is not to say that the family did not throw itself into the political ring only until after the sanction. So on a strict fact check basis, that's not accurate. In fact, the Mohammeds are Mr. Nandalal and his party's political comrades. They only parted ways after the pressure from the United States by way of sanctions. Secondly, political involvement is way more nuanced. Political actors know long before who are likely to be the contenders in the next election. It is not only after a person declared. And Azruddin Mohamed has been engaging in activities that seem that he was developing a political following for the past 5 years before he actually announced his candidacy. So one would be very naive to just simply look at the date that Azruddin Mohamed announced his candidacy and say that that was the only indication that he was leaning into politics, and that his opponents, who might have feared his performance in the political arena, could not have taken preemptive action in order to keep him out. Here's what I would say, that we might be looking at the 2030 race unfolding here. The Attorney General is likely to be a contender, and he might be likely looking at his opponent in 2030. Mr. Nandalal has a stellar domestic performance with respect to his work in the legal arena here. I think how he handles this extraterritorial matter is going to be a significant test for him. Significant success in this matter could shape his political destination in the near future, as well as bad strategy and failures here could dim his political star. And that's how I would see this matter impacting the political landscape. This is Caribbean Tea. Thanks for joining. Stay informed, stay engaged. Join us again next time. Thank you.